Another day, another AI case, and this one is really hitting the socials because it's Disney suing Midjourney. Yeah, these are two of the giants here. Not just Disney, Universal is involved. And since they're involved, that also means that Marvel and DreamWorks and all of those are involved because they're all these big conglomerates. And so this dropped just yesterday as I recorded. It'll probably be next week because I'm saving up a lot of these for vacation, but as we'll see, this will be pretty typical. In fact, it won't take us all that long to go through it, because so much of it is just repeating the same crap over and over and over again. And again, I'm the only YouTuber who is actually going through these briefs, instead of just screeching on social media about it. Yeah, Disney, go beat up on Midjourney because they're evil and everything, blah, blah, blah. What are they actually saying? And how good are their arguments? Sorry, but you're only going to find that one place, and it's right here. I wish that weren't the case. I wish there were other YouTubers doing that, because that kind of put some pressure on me here, especially since I'm not a lawyer. I'm just an artist. But I'm trying to go through all of these and make some sense of them and pass them on to you. But yeah, we've got this whole idea here of Disney going about the usual crap. Oh, AI is ripping off artists, taking all of their amazing creations from the past and churning them out into uninspired slop that is a cruel mockery of their creativity and originality. And that's our job. I mean, seriously, how many criticisms that people have of AI apply completely to what Hollywood's been doing, especially in like the last decade or so? One more uninspired crappy remake after another. Does Disney even have any original creations? They just bought Marvel, they bought Star Wars, and they just appropriated, Roger Rabbit and all of those others. They built their entire corporation on Cinderella and Snow White and stories like that are not original. Those are old fairy stories going back centuries. They have made their entire business model making content based on what other people created in the past. That is the big irony here. So we have their complaint. It's 143 pages. Do not be intimidated by that, because most of it we're not going to go through. This shouldn't take too long. It's really only 108 pages of the actual complaint, and the rest are appendices. And even at that, a lot of these intervening pages are just them posting pictures from Midjourney where they go like, ooh, look, minions. And of course, they go through all the usual stuff. We're Disney, we're Universal, we're the greatest. Midjourney sucks, they're terrible, they're horrible. So we're actually going to start here on page 56, where we see it's the usual stuff. So they say, Midjourney's AI service, through software programming and computer storage devices, embodies copies of those works, as that term is defined in Section 101 of the Copyright Act, in the AI software that powers the image service. Well, that's interesting, isn't it? Putting the word copies in quotes. Well, we know why they do that, don't we? Because they know, they have to know by this point, that AI does not work by storing copies and regurgitating them. That was the claim for the longest time, and that claim just keeps getting kicked out of courts. Because there's no truth to it at all. That's not how AI works. So basically what they're trying to say here is, okay, they're not actually copies, but they count as copies under the law. So you judge that for yourself, I guess. Alright, down at the bottom of the page they say, Midjourney downloaded from the internet and other sources content using tools variously described as bots, scrapers, string rippers, video downloaders, and web crawlers. So what? Regular viewers know that's been my response to so many of these. So what? Scraping is perfectly legal. As long as it's public data that's out there, as long as you're not like smashing your way past a paywall or a password protection or something like that. As long as you're just scraping publicly available data on the internet, you can do it, because that's what it means to be publicly available. Courts have said that time after time after time. Okay, next page, they're talking about preparing everything for training and getting it ready, making sure everything's filtered, making sure everything's curated. They say, this step necessarily included creating more copies of the materials obtained in the gathering phase, such as a new copy of each reformatted item, including plaintiff's copyrighted works. So again, They're trying to destroy fair use, your basic human right. See my other videos on this if you're curious as to why I say this and why this is so important. They're saying that like each time you make a new copy along the way, even if it's internal, that's an additional infringement. Whereas I explained before, you got the original thing, then you make a copy and another copy and a whole bunch of copies, and then you do stuff and you do stuff, and then you do some more steps, and then the final output. If any of those steps along the way is transformative, then the whole thing is fair use. And how much copying you did before that and how much detailing or whatever you did after that doesn't matter. As long as one step along the way is transformative, the whole thing is. And you also see a little further down the page how they're getting around this idea that AI training doesn't make copies. Because it doesn't. No copies of anything, no information actually enters the model from the training data. The data is used to train the model. It does not go into the model. And as I've said before, if AI training isn't transformative, then nothing is. And that means there is no fair use anymore. Midjourney's training of its generative AI model involved the fixation of copies. Okay, they're not copying it. They're just fixating the copies. They're trying to talk their way around that. The fixation of copies of plaintiffs' copyrighted works in a tangible medium from which the work can be perceived, reproduced, or... Okay, that's language from the Copyright Act. They're trying to say, okay, it's not a copy, but it's still a copy. In other words, Midjourney used software, servers, and other technology to store and fix data associated with plaintiffs' copyrighted works in such a manner that those works are thereby embodied in the model, from which Midjourney is then able to generate, reproduce, publicly display, and distribute unlimited copies, in quotes, of plaintiffs' works as defined by the Copyright Act. The fact they keep having to put copies in quotes is really telling. Because they're either copies or they're not. Next page, we're on 58 for those following along. Midjourney had to copy plaintiffs' copyrighted works in order for it to be able to subsequently disseminate reproductions and derivatives of plaintiffs' copyrighted works as outputs. Midjourney's unauthorized copying of plaintiffs' copyrighted works to train its image service infringes plaintiffs' copyrights in their copyrighted works. So basically what they're saying is just using them to train the model is now the infringing part. The output doesn't matter. The training doesn't matter. Using the copies to train the model is what's infringing. Do you see how they're constantly having to warp everything? Because they keep losing on everything else. And it's because they don't have a leg to stand on, but they try. Indeed, in true vending machine form, Midjourney distributes and displays copy after copy after copy of plaintiffs' iconic copyrighted characters to its subscribers and on its website as part of its Explore feature. These copies often contain extensive infringing nuance and detail, background elements, costumes, and accessories beyond what was specified in the prompt. Basically, they're talking about fan art. This was something we went through decades ago. They really tried pounding away to stop people from making fan art. That every piece of fan art ever made was an infringement of copyright, and they lost! Because that's not the sort of thing you can copyright. You don't copyright ideas, you copyright expressions. Those are two different things, and by doing this, they're gonna try to move backwards and win on the fan art thing again. Because that's what they just described fan art. Nuance and detail, background up, none of this has anything to do with fair use. There is nothing anywhere in fair use doctrine that says such and such is fair use unless it's detailed. No. There has nothing to do with any of it. Midjourney has faced widespread criticism. That's another big so what. Oh, a lot of people criticize you online. That's everything. You can make that claim about anything. For copying, publicly displaying, and distributing images of copyrighted works, including images of plaintiffs' copyrighted works. AI researcher Gary Marcus and film artist Reed Southern published a research article detailing how Midjourney generates copyrighted works and got it wrong. check out that X thread I had with Reed Southern when I was trying to just educate him on how this works, and also look at how terrible and nasty people like him get, and look at the elitism that these people have, and how they don't care about the tiny artist, the individual art shop owner or whatever. Whoever's doing this, the guy doing it out of his garage or whatever. They don't care about any of that. They crush underfoot because they got theirs. And there was one point where Reed Southern actually claimed to be one of the little guys. These people are so delusional. No, Reed, sorry. You are not a struggling artist. You're part of the corporate art. You're part of the man. Okay, a whole bunch of other pages where they just say, look at this, look at that, look, Minions, we got the Simpsons, we got everything. Yeah, they just keep going, don't they? So like I said, most of this gets skipped, and the important stuff pops up again here on page 101. Far from working with plaintiffs to address the concerns raised in their letters, Midjourney doubled down on its infringement. Midjourney didn't do anything wrong. I'm sorry, but they didn't. Oh, but they didn't want to address our concerns. They doubled down on not doing anything wrong. How dare they continue not doing anything wrong? If you're not doing anything wrong, you don't have to. Doesn't matter if some big corporation claims you're doing wrong. If you're not doing anything wrong, you're not doing anything wrong, and you don't have any obligation to kowtow to anything they say. So kudos to Midjourney for standing up to them. If Midjourney is not enjoined, it intends to continue to develop and scale its image service and thereby enhance its ability to infringe plaintiffs' copyrighted works. Indeed, last week, Midjourney CEO announced that Midjourney plans to continue deploying new versions of its image service and to launch its video service sometime this month. Oh, that's what they're worried about. You feeling that competition nipping at your heels there? Plaintiffs are informed and believe that Midjourney's forthcoming video service will allow paying subscribers to request copies of videos featuring plaintiffs' copyrighted characters and incorporating plaintiffs' copyrighted works, and will reproduce, publicly perform, and distribute videos containing and infringing plaintiffs' characters. Again, that was never supposed to be copyrighted. That was a bunch of that crap that happened in the 80s or 90s. You're not supposed to be able to copyright a character, or an idea, or a scene, or whatever. You copyright expression. And if the expression doesn't get copied over, it's not a copyright violation. For too long, the courts let them go way too far in the other direction, where they were cracking down on things like fan fiction, and they finally got them to acknowledge, okay, fan fiction is okay as long as you don't make money from it. That shouldn't matter. That shouldn't matter. I'm going back to the Orville, which was Seth MacFarlane's Star Trek fanfic, but he had changed so much that it wasn't Star Trek. Well, what if it had been a little more Star Trek? What if he had set it in the Federation, in the Star Trek universe, and had it be a Federation starship, and had it be in that continuity? There was a group of fans that had tried that, I think, back in the 90s, and Paramount came down hard on them, and got enormous criticism from all sorts of different directions, both legal and creative, because you're not supposed to be able to copyright a setting, or a universe, or characters or anything. You only copyright expression. But the courts kowtowed to them, and fortunately the courts seem to be turning around, because they're having to do this in jurisdictions where they don't have the fix-in with the judges. You know, if you can keep it out of any of the California districts, or keep it out of the SDNY, and get it in a fair district, they start getting tossed out all over the place. So it's good that the courts seem to be pushing back on this, but they just let them run riot for far too long. And it's time we step back into this. So this is right out of the horse's mouth. Oh, they're doing something with Minions. They're not supposed to own Minions. Minions are just an idea. It's what the Minions are doing, and who they are, and their character arcs that they go through, and things like that. That's the kind of thing that you can copyright. You're not supposed to be able to copyright the rest. Given that Midjourney's image service was trained on plaintiffs' copyrighted works without authorization and unbeknownst to plaintiffs, it is likely that Midjourney is currently training its forthcoming video service on plaintiffs' copyrighted works. Again, so what? Okay, this next page, we've got a real problem here. Midjourney's unlawful conduct has caused and will continue to cause substantial and irreparable harm to plaintiffs if it is not enjoined. Everything they talk in here is about money. Everything they say has to do with money. Midjourney's making money, and we're the only ones supposed to make money with our characters and so on. It's all about money. Legally speaking, if the harm can be remediated with a certain amount of money, it's not irreparable. This is not irreparable harm, even by their own description. Irreparable harm would be something like if, while the trial is going on, your free speech is being violated, or your rights are being violated in some other way. You're not allowed to have, say, this health procedure done, a medical procedure. You can't wait like 6 months, a year, 2 years for the conclusion of the case to have that procedure done, because your condition might get worse. You can't remediate that with money, and so that would be an irreparable harm. That's the sort of thing that's irreparable harm. Things that you cannot ameliorate with money on down the line. But everything they're talking about here is related to money. But they want to enjoin them. That means that they're not just saying, oh, we want to sue, and then at the end of the case, if we prevail, then stop them from doing it. That would be a normal court case. No, they want to stop them right now, before any evidence has been presented, before any facts have been adjudicated, before any discovery has been done. Go ahead and stop them from doing what they're doing right now. That's what it means to be enjoined. That's what they're asking for. And they don't have any basis for that. And this next one here is a laugh. Midjourney is also contributing to consumer confusion regarding what is lawful and what is not lawful by misleading its subscribers. No, that's you guys, sunshine. And that's what you've been doing for decades. Misleading people as to what is copyrightable and what is not. Because you want to control it all. Down to the very thoughts in our head. And if we dare to express those thoughts. We're supposed to be able to do that under fair use. That's what you hate, and that's what you're trying to destroy here. Alright, next page is page 103, even though it says 102 at the bottom. At least this one's only one page off. We've seen far worse in the past. As a direct and proximate result of the foregoing acts and conduct, plaintiffs have sustained and will continue to sustain substantial and irreparable injury for which there is no adequate remedy at law. No, the adequate remedy is there. It's paying money. You're talking about how they did this without paying a license fee or whatever, and how they're making money doing it. All that's monetary. That's the adequate remedy. There is no irreparable harm here. Unless enjoined and restrained by this court, Midjourney will continue to infringe plaintiffs' rights in their copyrighted works. Plaintiffs are entitled to injunctive relief. So they're saying just continued infringement is irreparable harm. No. No, because you can take care of that with money at the end of the case. They would just have to pay more money. That's how it works. Bottom of page 105. At all relevant times, Midjourney has derived a direct financial benefit from each act of direct infringement at issue. And so this goes back to a big misconception that I've been trying to correct here. Being commercial does not stop it from being fair use. That is one consideration among many, but if it is transformative instead of merely derivative, if the end product is transformative, none of the rest matters. And I've gone over the case law on that. I'm not even sure they cite any case law on this now that I think about it. They've pointed to articles and things like that. I don't recall, when I read this before, I don't recall any actual court case citation. So that's a weird thing that may come and bite them in the butt. I would imagine that in a case like that, the judge would want them to amend the complaint to actually reference the case law. By providing more generations and features to subscribers with more expensive plans, Midjourney encourages its subscribers to pay more for its service. Midjourney surpassed $200 million in revenue in 2023 and hit $300 million in revenue in 2024, despite the company's relatively short existence. Oh my God, they made so much money so fast. We want that money. And that's what it's all about. They're jealous that they made money quickly. And I'm not going to go over these next few pages, but they're kind of like what we saw with the Barks plaintiffs in the Anthropic case. You know, all of the hysteria and the table pounding, you know, using words like exploiting and other things like that. So let's go to 108, which is the actual last page of this. As a direct and proximate result of the foregoing acts and conduct, plaintiffs have sustained and will continue to sustain substantial and irreparable injury, it's not irreparable, for which there is no adequate remedy at law. Yes, there is. Pay the money. Unless enjoined and restrained by this court, Midjourney will continue to infringe plaintiffs' rights in their copyrighted works. Plaintiffs are entitled to injunctive relief. And they want plaintiffs' damages and Midjourney's profits in such amount as may be found. Alternatively, at plaintiff's election for maximum statutory damages or other amounts as may be proper. For an accounting, the imposition of a constructive trust, restitution of Midjourney's unlawful proceeds from copyright infringement, and damages according to proof. And both of those are money. All this is money. For preliminary and or injunctive relief enjoining and restraining Midjourney and all of its officers, agents, servants, and employees and all persons acting in concert or participation with Midjourney from copying, publicly displaying, blah blah blah, and from offering its forthcoming video service without appropriate copyright protection measures to prevent such infringement. Again, that would just be monetary damages, which means they're not irreparable, which means you shouldn't be able to get an injunction. But no, they want to stop them now. And they're also asking for prejudgment interest, attorney's costs and fees, and any further and additional relief the court may deem just and proper. Signed by a bunch of ambulance chasers. So yeah, another AI case to the pile. I will be following it. I will be letting you know what's going on with them. Most of them are kind of mired in the discovery phase now. Check my recent videos for how much of a threat that's being, because they're also wanting people's individual private data. People who are not in any way a party to these cases. They want the AI companies to take all of our information and keep it because they want to be able to ask for it in discovery. That's absolutely ridiculous. That alone should expose everything they're up to. As far as this case is, it's just more of the same. The fact that they had to keep putting the word copies in quotes should mean automatically that they know they don't have a leg to stand on. But we'll have to see how the judge reacts to all of that. Thank you so very much for watching. Comments for the Comment God. Shares for the Share Throne. Ooh, I stole that from Warhammer 40k, didn't I? Oh no! I breached their copyright. Oh well, please hit like, subscribe, and the bell anyway. And if the Warhammer people decide to sue me, I might need money, so please go to donate.pagosity.tv to keep me doing what I do. You can make a one-time donation or become a regular supporter and get these videos early and ad-free, participate in AMAs and live streams. Thank you so very much for watching. Until next time, stay strong and be free.